check case under the provisions of Ni 138 is criminal case for civil liability. However, the Supreme Court in Raj Khurana case in 2005 and reference 3-judge bench judgment in Yogin Pratap Singh case has mandated that the check law is fiction of law, so all its provisions have to be strictly followed for a complaint to be legally maintainable. Only check bounce is no offense, but only after all the provisions of its proviso are complied, then only legal complaint under Ni Act section 139 can be entertained. In the case of Rajpal Yadav, as it is gathered from press reports, that initial case of 5 crores was filed, which was compromised, and supplementary agreements were executed with fresh checks of higher value since included interest amount also. Mr. Yadav was jailed for bounce of subsequent checks. It is settled law that no provisions of check law are attracted for settlement checks. The holder of checks have option of reopening of earlier but original check case with condonation of delay application. The accused has option to file a civil suit for cancellation of so-called supplementary agreements since obtained illegally and on false information. What is false information? It is simple that all the proviso of section 139 were not legally followed and documents were not proved before final judgment by the complainant, hence the original complaint was not legally maintainable. The accused can also contest on the trial court when application is filed for reopening of original check bounce case. The judgment of the courts are delivered on the basis of evidence and defense of the accused. Many times proper defense is not presented and so the accused gets convicted. We give here some recent examples. In 2025, Lakhanlal Saroj was acquitted for murder case after 43 years in jail. In another landmark judgment, Supreme Court acquitted to accused in 1990 murder case in 2025 even though they had not filed appeal and only another co-accused had filed the appeal due to contradictions in first information report and evidence. In most of the cases, the evidence of the complainant is presented by leading questions which are not allowed and illegal. In Worky Joseph case, the Supreme Court acquitted him in murder case because the evidence of the prosecution was proved by leading questions. Power of logic is immense. Any fact can be proved wrong because there are limitations in written words and so many mistakes creep in any complaint. Even cross-examination by just leading questions which the defense has right, any complaint can be proved wrong by complainant's own admissions. However, in practice, just opposite happens. The complainant proves his case by leading questions and the defense is either absent or do not raise objections. While the defense has right the conduct crossed by leading questions but conducts by direct questions and proves the complaint which even the complainant had missed and gets convicted. That is why even there are hundreds of YouTube videos for legal advice, but still 90% plus accused gets convicted and suffer its results for a long time. Please send us all your documents and our legal team will advise actionable legal steps to be taken for legally coming out of any such case. While door is open but the accused tries to open the invisible lock and in the process get trapped in conviction. Thanks for visiting this video. Please subscribe for regular legal updates in such court cases.